Question number 4. We have confused in St. Clair Shores. And confused says, our father recently passed away. He left the home to all 4 of his children in his will. The problem is that one of our sisters died. We are now wanting to sell the property, but the real estate agent told us, the real estate agent told us that the title company requires us to first probate the property. But why? Isn't that why my father had a will? From Confused in St. Clair Shores.
Oh, yeah, okay. I think I understand why they're confused.
Mm-hmm.
Give me a second. First of all, boy, from the previous question, which was kind of fun, I'm sorry for this writer, who just wrote this in.
Mm-hmm.
Yeah, the transaction really isn't. See, I understand that they believe that the father's will is relevant to
Mm-hmm.
this fact pattern, but that's not what it is. The father had a will.
Mm-hmm.
It's not about the will. It's about how the siblings have come to own the property. And so they inherited the property, and they said there were 4 of them.
Mm-hmm.
One party or one of the sisters passed away. So the question becomes, how did the 4 children take title?
Yes.
That's really the issue. So when the realtor who's giving the news from the title company saying that they have to quiet the title, I'm going to assume they said quiet the title, right? Or do
that they would have to run it through probate first.
Oh, okay, probate.
Mm-hmm.
Back up, yes, it's been late. Yes, they do have to probate it, pardon me. And the reason they have to probate it is probably because of the deed and how everybody took title. And that's because if the siblings took title as joint owners,
Mm-hmm.
and one of the siblings die, the other 3 just siblings, the interest, that 4th sister's interest is dispersed equally amongst the remaining surviving siblings.
Okay.
It's automatic. It's not automatic when the deed or the ownership is stated in the deed is vested in what we call tenants in common.
Mm-hmm.
And so that means each child gets 1/4 of the property equal in those shares. But in the event of a death, it does not pass to the other co-owners.
So the survivors of the sibling that passed could potentially
has a right to that property.
Okay.
So there has to be, or a right to that sister or that.
The 25%.
That's correct. At 25%, the heirs to that sister have a right to her interest. Okay, and because of the ownership, if that sister did not have a will, then guess what?
Now it has to
be probated.
Probate. Yep.
Okay. And so this person is confusing the will that the father left. Like, well, he left a will. Why would we have to probate it? No, that was the father's will. The father did a good thing. He left the property through a will. So he did what he was supposed to do. The question is how title had been conveyed. And so whoever prepared the deed it probably should have been done joint with Rights of Survivorship, but there may have been a reason why it was done as tenants in common, where the beneficiaries to any of the decedents or the children would get the property. That's all.
Okay.
Very, very good question. Sorry for your loss.
Good.
And that is why you have to have an attorney handle the conveyance instruments, okay, which is the deed.
Okay. That is a good question.
Right, great question. That's actually, I think that's one of the, I know you like that second one that we did, but this one is a really good one. Yeah.
No, yeah, the second one hits home just because of lawsuits and business partners, et cetera, and the light bulb that went on over my head of just something that you could do. But this one is So I'm studying, loosely studying to get my realtor's license, and
Yeah,
so I am learning about the different ways to hold title, and it's enlightening, and it's just things
yeah,
that you don't. It's just things that the average person who doesn't deal in real estate transactions on the regular, you just don't think about it. You're just like, well, there there were four and now there's three, and the will said, and you
right,
just don't think about all those different categories that could, you are slotted in, and it's like a flow chart. If you're slotted here, then you flow here, but if you're slotted here, then you flow over here, and you have to follow the pattern
right.
of
Right.
whatever it is that you've been slotted into.
And the
Oh,
way
that was
that
good.
that flow chart works is
Hmm.
all determined by, I call it legal magic language.
Yes.
And if you
Yep.
don't have the legal magic language, you will screw everything up.
Hmm.
Sometimes to the point that you will have conveyed a piece of property when you wish you like hadn't conveyed it in a certain way,
Hmm.
but it will be no matter. You'll never get it back because you conveyed it without any rights to recoup that property.
Hmm.
So they call it alienation. You do such damage, you'll never get the property back. So there are people, in fact, I just handed a quitclaim deed to a client of mine today, who for the past 5 months, she and a renter did the deal on their own, and she had never done a transaction before. And what do you think she did? She quitclaimed her interest over to this other
Hmm.
party before they had paid her off.
Yep.
And they were relatives, which made it even worse.
Yeah.
And the relative refused over these past many months to give the property back.
Hmm.
So you know what we did, Blair? We filed a lawsuit against the relative and showed them the errors of their ways,
Hmm.
and the court agreed and compelled the cousin to relinquish a deed.
Wow.
And it cost, I'll just tell you, it cost my client close to $13,000 in court to
Wow.
do that. All because of a deed that the people wanted to do
Hmm.
online on their own.
Pay me now or pay me later.
That's right. Didn't understand the nature of the transaction in total. And
Right.
when I'm telling you the figure, I'm not doing it. There's no happy, it is what it is, but I don't say it being happy because honestly, there was a lot of work and a lot of emotion,
Hmm.
and the people were just going to kill each other. And it just was so sad to see how this family deteriorated. And family members took sides. So, and I got letters from people. It was crazy. So why would you do all that stuff, right? The
Hmm.
magic language.
Yep. That is too bad.
Yeah.
All right. Well, that was a very good question from
Yeah.
Confused in St. Clair
Great
Shores.
question.
Okay, let's move on to now. We're moving on to angry.